I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. This is number 246 on our compilation list. Welcome, welcome, welcome. Thank you for joining me as always. 3 judges' courtrooms we will be sitting in on today. And before I give you the 3 names of the judges, don't forget to like, comment, share, and subscribe. You guys have been amazing at that. Also, commentary will be left in the proceedings where there were commentary before. Chapters will be added for your convenience. And now let's tell you who the featured judges are for this compilation. First, for the first time, we will be in the courtroom of Judge Matthew Saber out of the state of Indiana, and shout out to Sovereign Citizen Chronicles for sharing this proceeding with me. Second, we will be in the courtroom of Judge Corrine Magid out of the state of Colorado. And last but not least, we will be in the courtroom of Judge Raeigen Evans out of the state of Michigan. Guys, as always, thank you for joining me here on Sovereign Citizens Hall of Fame. And now let's jump into 246.
Is the one individual unable to stand, or?
Yeah, I got a bad hip.
Thank you. Do you swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you. You can all have a seat. I need Mr. Heights to come on up to the front. There, sir. Mr. Heights, can you please state your full name?
My full name is Jack Lewis Heights.
Thank you.
Capital,
what is your date of birth?
Capital J, lowercase a, lowercase c, lowercase k, capital L, capital H, lowercase e, lowercase I, lowercase t, lowercase z.
What is your date of birth? Thank you, sir. Do you have a copy of the information in front of you?
Yes, whatever information I was given, yes.
You should have 2 documents, the initial hearing order and the information. And the information is the document that is a single page titled Information in the upper third in all bold and all caps. It reads as follows: that you are alleged to have committed on January 14, 2025 here in Marshall County, state of Indiana, 1 count of auto theft, a level 6 felony, where it's alleged you did knowingly or intentionally exert unauthorized control over a blue 1997 GMC Sierra, the motor vehicle of Daniel Cervantes Quintes, with the intent to deprive the same individual of the vehicle's value or use. Now, Mr. Heights, I'm not asking that you agree or disagree that you committed that offense, but do you understand what it is that the state is alleging?
No, I don't.
In what regard don't you understand?
I've never been in Marshall County ever in my life, so I don't understand how I could have exerted control over a vehicle in Marshall County. I was simply riding in a vehicle in St. Joe County, which is St. Joe County jurisdiction.
Mr. Heights,
if I was,
Mr.
so
Heights,
I don't understand the nature of the charge, no.
Mr. Heights, I want to point out again, as my question was clearly worded, I was not asking whether you agreed or disagreed with the charge. I was just asking whether you understood what the state was alleging. And to do you one additional favor, I will read you the statutory offense for auto theft, if you just give me a moment. That should clarify what the state is alleging. And certainly, I'm presuming that you're innocent of the charge, as I indicated to you. And so therefore, the not guilty plea will be entered on your behalf, and then we can move this case forward to some hearing dates as well as potential trial if you are disputing the charge, ultimately after discussing with your attorney. So give me one moment, sir. Statutory offense of theft as charged by the state reads as follows: a person who knowingly or intentionally exerts unauthorized control over the property of another person with the intent to deprive the other person of any part of the use or value of the property commits theft, a Class A misdemeanor. However, the offense is a level 6 felony if the property is a motor vehicle, and that is under Indiana Code 354342, subsection A1B Romanet 1. Does that help you understand what the state is alleging?
No, sir, I don't understand that. I was never in possession of this vehicle. I was just riding in it. I was just a passenger in it.
And it sounds as though you're disputing the charge, but what portion?
I'm not disputing. I'm saying I don't understand the nature of the charge. I was never in Marshall County. I was never in possession of this vehicle. I was just a passenger. I was never questioned during the course of when this vehicle was in a snow ditch. I was just helping somebody push the vehicle out of the snow ditch. No police never asked me any questions about it. I was never informed of anything at the time. I was sent to the hospital because I was hypothermic, helping somebody push a vehicle out of a snow ditch. I've never been in possession of this vehicle at any point.
All right, Mr. Heights.
I don't understand any of that.
I appreciate that, sir. Here's what I'm going to do. For the jail staff, I'm going to have Mr. Heights have a seat in the back. I'm going to conduct the other initial hearings, give him a moment to read the information more thoroughly. I encourage you to read over the initial hearing order as well, Mr. Heights. And then you and I will have a discussion after I've concluded the other two initial hearings about your initial hearings moving forward.
Yes,
Thank
sir.
you. We'll stay in recess in this case. Mr. Looney, can you come on up to the front? Okay. Mr. Heights, come on up, sir. This is again 50D032605 F6107, State of Indiana v. Jack Heights. He's back present with us, and I recessed Mr. Heights' case because he wanted, or I should say, I was going to give it an opportunity to review the information in the case to make sure that he was understanding what the court was asking as well as the nature of the charges. And I just want to refresh some of your recollection, Mr. Heights, in the sense that first, I place you under oath at the beginning of these proceedings and you remain subject to that oath. Second, I am presuming that you're innocent of these charges and entering a not guilty plea on your behalf. Third, today's hearing is largely procedural in nature, and so it is not necessarily about the disputed facts of the case. The state is not presenting any evidence of your guilt. They have not made any statements asserting that in any way. The court has only found a probable cause determination to essentially hold you now, and I was going to address that with you at the conclusion of your case of what your bond would be. And so the reason I raise that is that you are presumed innocent of these charges. There is no need to make any factual assertions about the case because today's hearing is not a hearing where factual assertions will be made. And then finally, to that point directly, because you're under oath, any statements you make here today could be used against you. And so if there's any sort of statements that you unintentionally make or intentionally make that could be construed as incriminating, they could be used against you. Mr. Heights, do you hear that recitation that I just provided to you?
I heard you, yes.
And as I indicated, we were at the stage where I was going over the information in your case. Do you still have a copy of that in front of you, sir?
I do.
And it charges that one count of auto theft, which I'm presuming you're innocent of, entering that not guilty plea. But the main question I have for you is there is a statutory charge that the state has filed this under. I recognize that you dispute that charge and do not believe you committed that offense. And I'm not saying that you did, nor am I finding that you did, but I'm just trying to make sure that you understand that the state is alleging an auto theft charge and what that charge entails. Does that help you understand what I'm asking?
No, sir. I don't understand that Marshall County is stating that I was in possession of a vehicle where I was in a vehicle in St. Joe County. Marshall County has no jurisdiction on what happens in St. Joe County. So if Marshall County is saying that they have irrefutable evidence proving that I took the vehicle or eyewitness testimony saying that I took the vehicle from Marshall County is one thing, but to say that Marshall County is alleging that I was in possession of something that was stolen out of Marshall County in St. Joe County, that's not Marshall County's jurisdiction. That's St. Joe County's jurisdiction. So therefore, I don't understand the nature of the charges being out of Marshall County. It should have been out of St. Joe County. Do you understand that?
I understand what you're saying. You're essentially mounting a defense here today, which I've tried to explain to you is a factual.
No, I'm not mounting a defense, Your Honor. I'm simply stating the facts of the situation as it's presented to me on paper. How does Marshall County charge me with possession of something where I wasn't even in Marshall County when I was found as an occupant in a vehicle?
Well, the mechanics of the charge is that they review a investigative report. They then prepare the information. They also then submitted an affidavit of probable cause from the investigating officer in the case. That affidavit of probable cause was submitted to the court on April 23rd, 2025, filed in the court the day that the information was filed. There was an order finding probable cause signed by one of the judicial officers here in Marshall County that set your bond, as well as found probable cause for the offense of auto theft.
Who found probable cause of auto theft, though? I don't understand. I wasn't in Marshall County. There's no evidence to prove that I was in Marshall County ever in my life. I was an occupant in a vehicle in St. Joe County, and nobody ever asked me any questions. This case is 1.5 years old. I'm the one that contacted Marshall County when I found out about the case to try to clarify the situation. I'm the one that tried to rectify everything. I would like to know who gave probable cause to charge me. Was it a grand jury? I have a constitutional right to a grand jury. I feel like the prosecutors have used their discretion in charging me with a crime that didn't even occur in their county, that they can't even show that I was even in their county. They have no irrefutable evidence showing that I was ever in Marshall County. I was pulled over, not even pulled over, I was pulled up on by an officer pushing a vehicle out of a snow ditch in St. Joe County. That's not possession of an automobile. That's not possession of, that's not theft in any way. So therefore, I don't understand the nature of being charged with a theft when I was never in Marshall County. And there's no evidence that can ever state that I was in Marshall County. There's no video evidence. There's no eyewitness testimony that's ever going to put me in Marshall County stealing anything.
Let me ask you this, Mr. Heights. Do you know what theft is?
Yeah, theft, I'm assuming, is taking somebody else's property.
Correct. I read it to you earlier about the exerting unauthorized control over the property of another. And
I wasn't in control of this property.
And I didn't, that was not my question. Do you also know what a motor vehicle is?
I know what an automobile is, yes.
And so
a motor vehicle is a commercial vehicle used for commercial purposes on the highway.
I didn't say commercial motor vehicle. I just simply said motor vehicle. But
motor vehicle, by definition of Black's Law Dictionary, is a commercial vehicle used for commercial purposes on the roadways.
And so you know what theft is, you know what a motor vehicle is. And so if you combine those two, you understand what theft of a motor vehicle is. Is that fair to say?
No, I'm not understanding how I'm being charged with theft of a motor vehicle.
Again, that was not my question. I just putting all this together and just simply logicking through this. You understand what
you're arguing semantics, Your Honor. You're arguing semantics is what you're doing. I'm telling you that I was never in Marshall County, and there's no evidence that can ever put me in Marshall County. I've never been here. I've never been to the city of Bremen ever in my life. So how did I steal a vehicle? I think I was incarcerated in St. Joe County Jail, as a matter of fact, at the time of this incident.
Mr. Heights, let me ask you this. Do you understand that we can get through this hearing today and we can go over your rights and we can go over your attorney status and we can then certainly assert your innocence as you're doing? Or
can we go over my right to a fast and speedy trial? Can we go over that?
I'm trying to get through understanding that you know what your rights are, but we haven't got to that point yet. My question is, do you understand we can go through those things? Or if you simply can't answer yes or no to certain questions, we can recess the hearing and I'll call you back tomorrow and we can bring you in tomorrow to go over this hearing. It's your choice, Mr. Heights.
That's not going to change my understanding of the fact that I've never been in Marshall County ever in my life.
And I can
and how I'm being charged with a crime for being in Marshall County, and I've never been here. I was not pulled over in a vehicle. I was an occupant in a vehicle in St. Joe County. So that's St. Joe County's jurisdiction if they choose to charge me with possession of a stolen vehicle. You're charging me with theft of a stolen vehicle, meaning that I was in Marshall County and stole the vehicle from Marshall County. Unless the state's saying they have irrefutable evidence, video evidence, or an eyewitness testimony placing me in Marshall County, then what probable cause did they use to even charge me? They're abusing their discretion. It should have went through a grand jury. I wouldn't be indicted on a charge through a grand jury with this type of evidence. Ever. That's my constitutional right to a grand jury. The prosecutor is abusing their discretion. They're going off of information that's not true. I have never in my life been in Marshall County, ever in my life. Have definitely never been to the city of Bremen. So unless the prosecutor sent under oath that they have eyewitness testimony or video evidence placing my face in the proximity of this vehicle in Marshall County, me being pulled over in St. Joe County, not even pulled over, but pulled up on, pushing a vehicle out of a snowbank for somebody, is not theft of a motor vehicle.
Thank you for your opinions, Mr. Heights here. And what I'm going to do is find that the defendant is unwilling to go forward with answering questions here.
You're asking me if I understand the nature of this cause, and I'm telling you that I do not understand the nature of this cause.
Well,
how can I understand the nature of being charged with an auto theft from a county that I was never in, that they cannot prove that I was ever in, that I was not, that the vehicle was not even found in Marshall County? This should be under St. Joe County's jurisdiction, not Marshall County's jurisdiction. I'm arguing subject matter's jurisdiction. I'm arguing subject matter jurisdiction. I apologize. I don't mean to interrupt you, Your Honor. I'm just a little frustrated here.
I completely understand that. I'm going to give you 24 hours to cool down and think about it. So we'll recess the hearing. I'll see you tomorrow. You remain subject to the bond previously set.
All right.
Thank you for the jail staff as well.
So you guys all ready to?
Friend. And sir, I just want to advise you, you can't exercise law. You can't practice law with Miss Hanine. That's not that's Mr. Schmidt sitting on that's his friend. And sir, I just want to advise you, you can't exercise law. You can't practice law without a license. And so you're not his attorney. You can't represent him. So you have to, we've already been through this. So I just want to make sure that that's clear, that the other gentleman's Mr. Schmidt. His friend has tried to represent him previously. I've given him some advisements on that. Thank you. You need to take a seat. You're not a party to any of these cases. And I'll just advise you that if you keep interrupting the court proceedings, you could be held in contempt of court. You could be facing up to 6 months in jail. So you need to follow the court's rules and the requirements of the courtroom. Thank you. Okay, thank you. I'm happy to make those findings and impose a jail sentence if you don't comply. All right, and we are here for a pretrial readiness conference. I'll just make a record that Mr. Schmidt did file some further legal filings. I have issued a written order denying those, and so I won't take additional argument regarding the arguments that Mr. Schmidt already made. I just found that they were not based in law, and so I have denied those. Today, we're just going to find out if people are ready for their trial. So for the prosecution, we are set for trial next week. Will you be ready to proceed?
Your Honor, and I wanted to provide the court notice that when I took over this case, I reviewed it, and I will not be proceeding on count 5, the obstruction of government operations charge. I did some case law research. I don't think it fits under several cases. So at trial, my plan is to only proceed on counts 1 through 4.
Okay, so you're formally moving to dismiss?
Yes.
Count 5? Okay. Mr. Schmidt, then that leads only traffic offenses. And I guess he's charged with failure to provide proof of insurance, so he'd still be entitled to a jury trial as there's potential jail on that offense up to a year. Mr. Schmidt, did you want to speak with the prosecution to see if you could come to some sort of resolution in the case based on that they've dismissed that misdemeanor case? We're taking a record, so I do need you to answer out loud.
It's not a misdemeanor. felony.
Okay. Well, the obstructing is a misdemeanor under Colorado law. So that's been dismissed. Now what you have faced with you is 2 counts of unregistered vehicle or a count of fictitious plates, a seatbelt not used, and failure to display proof of insurance. So the question for you is it sounds like you would still like to proceed to trial, or do you want to talk with the prosecution to come to some sort of resolution?
No, ma'am. While I'm sitting here trying to contemplate whether or not I'm going to file judicial criminal complaint against you and sue you personally, who said that I was a sovereign citizen? You did. I never mentioned sovereign
Okay,
citizen.
Mr. Schmidt, I'm going to give you 5 minutes to make your record, and then
That's fine.
Go ahead.
Charge you 4 counts of defamation, libel, and slander. You're ready to do that. I want everything from the last hearing vacated. I want this stricken from the record. To say I'm a sovereign citizen is an oxymoron, number one. Number two, you're automatically falsely labeling me a domestic terrorist. And I object to that strongly.
Okay, you have about 3 more minutes to make any other additional record that you'd like to make.
And I got your motion or your order 3 days ago. It says motions. I only filed 1 motion. The others are notices. And I would like to see the statutory authority that allows you as a county court clerk or court judge to make a ruling on an appeal from another judge's court. Do you have that available?
Any other record? I'm going to give you, this isn't a back and forth, Mr. Schmidt.
I'm done.
So it's not a dialogue. I'm allowing you to make the record, I rule, and then we go forward. So you have additional, probably about 2.5 more minutes if you'd like to make any additional record.
Did you rule on your appeal yet? If not, then it's on hold under an appeal, interlocutory appeal. It's an automatic stay.
Any other record? You still have time to make any additional record that you'd like to make.
I yield.
Okay. Based on the record, I've already filed and made an extensive record at the last hearing regarding the interlocutory appeal issue. I have found the court has jurisdiction. I'm not going to revisit those. What we have done now, Mr. Schmidt, is you've created a record. If you find that I've made mistakes, you can always appeal me, but ultimately we're set for trial next week. And so for the prosecution, you will be ready to proceed?
Yes, Your Honor.
Mr. Schmidt, will you be ready to proceed?
Nope.
And what is the grounds?
That you're incompetent.
Sir, I will not sit for you insulting the court. You could be held, let's just, sir, I'm just going to give you a quick warning. You could be held in contempt of court if you are violating the court's orders or the court's decorum. You're facing up to 6 months in jail. So we are talking about the legal issues. You cannot insult the court, or else I'll just hold you in contempt. So the question for you is, will you be ready to proceed for trial?
No.
Okay, are you moving to continue?
I do request to continue.
What is the grounds?
That I have filed an appeal already, an interlocutory appeal.
For the prosecution, what's your position on the defense's motion to continue?
I'd object to that motion.
Okay. Based on the record before me, I've already denied that request or made a record regarding interlocutory appeal. I find that the defense has not raised good cause to continue the trial. Any other record, Mr. Schmidt, I'll allow you to make for 2 minutes. Okay. Your trial is the only case set on Thursday, so you should be ready to proceed. Has the prosecution have any notice that he's picked up discovery?
I can check on that, Your Honor. Should have a letter if he did. I'm not seeing that he has picked up discovery.
Okay.
We normally have a letter that he has, but it's not in our file.
Mr. Schmidt, if you want to know the evidence that's against you, you need to stop by the district attorney's office and pick up discovery. You ultimately need to be prepared for your trial. So it's your choice if you decide not to pick up the discovery. Discovery is the evidence that the prosecution will present at your trial. I will just tell you that we have certain very strict procedures for trial. I would suggest that you watch a trial before next Thursday so you have an understanding of what's going to happen. You have made arguments that I have ruled are not based under the law. And I will tell you that I will not allow you to make those arguments before a jury because the jury is going to make a determination as to the facts of the case and whether you are guilty or not guilty of the offenses charged. So I just want to set your expectation that you will have to proceed to trial with an understanding that the court will not let you raise those arguments. You've already raised them. I've denied them in a lengthy hearing. I've also denied them in writing. So on the day of trial, I'll explain quickly the procedures of trial, but ultimately you'll have to make a decision of how you are going to proceed. You've had a gentleman here with you previously. I made it clear that he cannot represent you. He is not a licensed attorney who has entered on the case. He cannot help you during trial. You cannot whisper to him. I allowed for you to talk with him during the motions hearing, but this is different for jury trial. So ultimately, if you would like to be represented by an attorney for the public defender's office, Colorado does not have a procedure where I force an attorney upon you. You must apply for the public defender and show that you qualify. At this point, you've made choices not to be represented. If you qualify for the public defender, then you can have an attorney enter on your case. You can hire an attorney. Ultimately, trial is next week. You've raised these legal arguments. I've denied them. We're proceeding to trial. And so you should be ready with the evidence picking up the evidence and understanding what evidence is against you. Any record, Mr. Smith, that you'd like to make, I'll give you 2 minutes.
He is a licensed attorney, federal licensed attorney. 7406, if you'd like to look it up.
You have about 1 more minute if you'd like to make any other argument.
And he is my tribal counsel.
He has to be licensed in Colorado to practice law. He's not filed a formal entry of appearance, and so he cannot represent you. You'll be representing yourself unless you take steps to hire a licensed Colorado attorney or you apply for the public defender. Trial is set at 8 a.m. on June 4th, and so everyone should be prepared to proceed on that date. For the prosecution, do you have that information on how we can pick up discovery?
I do, Your Honor. I have a piece of paper right here.
Okay, all right. And for the record, then, Ms. Hanine is handing that to Mr. Schmidt. Mr. Schmidt, you can take steps to pick up the discovery in the case. And ultimately, for the prosecution, did you want to lay out for the record what the plea offer is in the case?
Sure, Your Honor.
And just for the record, under the law, the court is going to have the prosecution make what's called a Loeffler record, which is a record regarding the plea in the case. So Mr. Schmidt understands what plea offer he's rejecting.
So, Your Honor, I haven't been able to convey this to Mr. Schmidt yet. He refused to talk to me without his friend present. I didn't feel comfortable doing that. I don't think his friend understands that he is not his attorney. But I would dismiss the case if he obtained Colorado insurance.
Mr. Schmidt, did you understand that if you get Colorado insurance, the prosecution would dismiss the case? We can proceed to trial. Ultimately, I think I've talked to you already about the possible penalties that you're facing, but it's your choice if you decide not to get insurance. But if you'd like to take the prosecution up on that plea offer, you can contact them. Any other record, Mr. Schmidt? I'll give you 2 minutes.
I do not understand. I do comprehend.
Okay, you have 2 minutes.
I yield.
Okay. Good luck. We'll see you back here on June 4th at 8 a.m. Don't be late. If you're even 15 minutes late, you can have a warrant for your arrest. Thank you, sir.
Says District Court is back in session with the Honorable Raeigen Evans presiding. While court's in session, there's no reading, walking, talking, driving, eating, smoking. When your name is called, please give your full and undivided attention to the court. Good morning, Your Honor.
All right, good morning. This is the People versus Carlos Durham. Ticket number 20397-842, count 1, drove while license not valid or improper license. Ticket number SP115463, count 1, drove while license not valid or improper license. And it looks like we're here for a review on ticket number U40128517. The conviction is disorderly conduct. Good morning. Please say your name to the record.
I'm here, Your Honor. My name is Carlos. My name is Carlos of the Durham family, and I'm here as executor of the estate named in this matter and beneficiary. And I appoint you, the judge, as trustee. My name is Carlos. My name is Carlos of the Durham family, and I'm here as executor of the estate named in this matter and beneficiary. And I appoint you, the judge, as trustee to dismiss this matter.
You can't appoint me as a trustee. I'm not the trustee on this matter. I'm the judge of this matter. And we're not dealing with any beneficiaries or any of that. You're dealing with the defendant. And it's my understanding that you are Carlos Durham and you're the defendant in this matter.
Do I have a right to subrogation? Does the prosecutor give me the right to subrogation? Do I have a right to subrogation?
I don't even know what that is. What's subrogation?
I require subrogation.
What is that?
You don't know what subrogation is, Your Honor?
I don't.
Okay. Are these proceedings being recorded?
They are.
Is your bond and oath of office valid, current, up to date, and still in effect?
I'm an active member of the bar.
For the record, please present your bond and oath of office to the court. The prosecution bonded for this matter.
The prosecutor is not present right now, Mr. Durham, but I don't have to do that. So
I'm here at special appearance, and I'm here for the purposes of demurrer. All rights reserved under my full God-given name, Carlos Lorenzo Durham, as indicated by this birth certificate.
Mr.
Right
Durham,
here.
Mr. Durham,
I am also the sole beneficiary for this legal entity.
Mr. Durham, everything that you're stating does not apply to this court, sir.
So the Supreme Court and the Constitution doesn't apply to this court? What jurisdiction is this court operating under? Common law or admiralty jurisdiction? Because those are the only two jurisdictions that's mentioned in the Constitution. Which jurisdiction is this court operating under?
Either. We're operating under state law.
So it's operating under statutory? Is it operating under statutory jurisdiction, Judge? Because if it is, I need to know the rules and procedures for statutory so I can defend myself. Could you tell me where I can find a copy of that?
Mr. Durham, we're operating under the law of the city. These are city ordinances and these are misdemeanors.
Those are not laws, ma'am. I'm American State National, ma'am.
Mr. Durham, these are your options today. This is, one is already set for a review because it looks like you already made admissions. It looks like you pled guilty to one charge.
I didn't plead guilty to nothing. I didn't plead guilty to nothing, ma'am. I didn't plead guilty to nothing, ma'am. A judge was operating.
Mr. Durham.
I didn't plead guilty to nothing, ma'am.
Mr. Durham, how this can work, we both can't talk at the same time. So you need to be respectful and let me say what I need to say. I've let you say what you needed to say. So you need to let the court speak now. So you've already pled guilty, sir, in 2017. Or no, your plea date actually was October 4th, it looks like. And you were charged with offer to engage the services of another for an act of prostitution, it was amended to disorderly conduct. And so we're here for a review on that matter. We have 2 charges of drove while license not valid or improper license. The offense date is October 18, 2020. And then there's another drove while license not valid or improper license charge with the offense date of January 14, 2021. Now, today, you can either set these for, they're already set for a pretrial. So you can set this for a trial, which it could be a bench trial, where the court, meaning the judge, myself, would decide if you're guilty or not of these offenses, or you can set it for a jury trial. Those are your options, sir.
So my option today is not to challenge jurisdiction, because when jurisdiction is challenged, everything must stop and jurisdiction must be presented. You must prove your jurisdiction. It right now. Everything must stop and you must prove your jurisdiction right now.
You're incorrect, sir. I don't have
Ma'am, I'm incorrect. Your oath of office says you're supposed to uphold the Constitution and all laws pursuant. The Constitution says I have rights, and you're not giving me, you're violating my rights by not telling me what jurisdiction we're operating under. Prove your jurisdiction, ma'am.
I'm not violating your rights, Mr. Durham.
Prove your jurisdiction, ma'am.
I don't have to prove my jurisdiction.
So yes, you do, because jurisdiction, when it asks to be proven, must be proven. If you're exerting authority over me, you must prove your authority. Prove your jurisdiction, ma'am.
Mr. Durham, what we'll do is we'll set this for a jury trial. And so I
want a jury of my peers. I'm an American state national, so I get 6 American state nationals as my jury. I need the prosecution to send me my right to subrogation in writing. I need your oath of office and your bonding information so I can make sure you are who you say you are and who you claim to be and what your duties and responsibilities are. All public officials must be bonded. I need all of y'all for full disclosure. Am I getting full disclosure right now, ma'am? I need full disclosure before I can make any decisions.
I've told you all that. So
no, you did not tell me all that. I need the name and the address of your bonding company and your policy number to make sure your oath of office is current. I need all of that.
That doesn't apply here, Mr. Durham.
Really now? The law doesn't apply to you. You're above the law is what you're saying.
So I'm going to set this for a jury trial, sir. What I'll do is, do you want to retain your own attorney or are you going to represent yourself?
Ma'am, I'm only here for the one purpose of subrogation. Nobody has given me nothing what I asked for, but you keep trying to force yourself on me.
I'm not forcing anything. You're here for something that doesn't apply to this court, Mr. Durham. If you're here for
so why don't you dismiss the case? Because I was not driving, I was traveling, ma'am.
As a defendant. You're not here as a
No, I'm not here as a defendant, ma'am.
Beneficiary.
I'm here as a beneficiary, ma'am.
You cannot come here and tell me how it's going to work. That is not how it goes.
So I need full disclosure. Am I getting full disclosure?
Absolutely.
Yes or no?
Yes.
What jurisdiction is this court operating under? Common law or admiralty jurisdiction? Which jurisdiction is this court operating under? Statutory jurisdiction?
The jurisdiction of the city of Detroit.
Is that statutory? Is that statutory? Because the city of Detroit don't get to overrule the Supreme Court or the Constitution. And it says if it tries to do that, everything you do is null and void. The Constitution overrules the law of the land, and that's what I'm under.
In order to be heard by the Supreme Court, Mr. Durham, you have to first go through the district court. And
no, ma'am, that's not true. That's not true, ma'am.
Agree with it, then you can appeal it. But as of now,
I asked to see the lawyer's bond. I asked to see the attorney's bond. I asked to see the contract you have, so I can.
Do you want to retain your own counsel, Mr. Durham? He's muted. We'll just it just looks like that you're supposed to pay the fine of $50. So we'll just have you pay that on the next day by the next time you come back, which will be January 17th. So you need to pay the $50 by January 17th at 8:35, which is your next court date. And then your jury trial date is February 7th at 1:35. All right, so you are all set, Mr. Durham.
Mr. Durham is saying something, but he's still muted.
Mr. Durham, you are muted, sir. I don't know if you know how to unmute yourself. It's the bottom left-hand corner.
I object to these proceedings.
Your objection is noted, Mr. Durham. So you got your jury trial date, and then you have your pre-trial date, the final pre-trial.
Okay, when is the prosecution going to send me all the evidence, including the witness, the damaged property, and the injured party's name? I need to know everybody involved. I need all this information.
Of course you do. Mr. Durham, what that is called discovery. And you have to do a request in writing.
Ma'am, I'm not part of your society. I don't have to follow those rules and regulations because you can't tell me where to find the rules and regulations for statutory jurisdiction. Where can I find a copy of the rules and procedures for statutory jurisdiction? Because that's what you're operating under, statutory law, right? A statutory jurisdiction. Where can I find the rules for that? Can you tell me where I can get a copy?
You have your request in writing for discovery, okay, sir? And she should be able to give you the police reports or whatever she has. She can email it to you so that you can prepare for trial.
Are you going to give me your oath of office and bonding information? That's including the name, address, and policy number of your bond? Are you going to give me that?
I don't even know what all of that is.
Your public officials surety bond, just in case you violate my rights. All public officials must be bonded. You don't know what a bond is?
No, I don't.
I'm gonna write the treasurer, and they're gonna tell me the name of your bonding company. I'm gonna write the treasurer
myself. So I'm giving.
So you're not bonded. So you're not bonded, is what you're saying.
I've given you all the information that you need.
Okay.
This hearing, so you are all set, Mr. Durham. Unless you had other questions, you are all set, sir.
Yeah, I do have questions, but you won't answer them. You won't answer none of my questions. Are you operating under a statutory jurisdiction, a common law jurisdiction, or admiralty jurisdiction?
This matter is concluded, so you're all set.
Oh, so okay, I understand now. The bully tactic. Don't nobody want to answer questions, but they want me to comply with. I don't understand that. How am I supposed to have compelled performance if y'all don't want to answer no questions?
Well, guys, we've come to the end of this proceeding. And just like I told you guys, I figured Mr. Durham would have his super sovereign citizen head on, and he did. I felt Judge Evans handled the situation pretty well. Didn't really do a whole lot of back and forth with him. I mean, he kept bringing up something called subrogation. And she asked him, well, what is subrogation? And when she asked him again to explain it, you know, just like most sovereign citizens, he jumped on another bandwagon jurisdiction, this and that. And then eventually he came back to the subrogation, but he never explained what it was. And we see some of his charges: driving with an invalid driver's license. I was shocked to see the whole trying to pick up a prostitute thing, you know, because a lot of times when you hear these sovereign citizens talk, you know, they talk like they're just on this whole other level. So to see that he was charged with, you know, trying to pick up a prostitute, that was pretty interesting. But also we see he was going so hard that she just had to straight up mute him, and you just see his lips moving. It's like, you know, she told him, you're muted, and he still was just trying to talk until she eventually told him how to unmute the call. But with that being said, you know, basically the case has been continued, and this guy has multiple cases out there, some minor, some pretty major. If you guys want, I will go and find some more of his appearances. I didn't really keep up with him after that last appearance. So if you guys want me to find some more of his appearances, because I believe there's a lot out there, I will do so. But with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. Don't forget to subscribe, like, and share. Appreciate you guys. God bless.